Welcome and thank you for standing by. At this time, all participants are in a listen-only mode. To ask a question during the question and answer session, please press *1 on your touch-tone phone. Today's conference is being recorded. If you have any objections, you may disconnect at this time. I would now like to turn the meeting over to Eileen Nandi. You may begin.
Thank you. Good afternoon, everyone. Thank you for joining us for our webinar on Top 10 Financial, Legal, and Customs Tips to Export to India. It's part of our South Asia webinar series. We're very glad to have you with us. My name is Eileen Nandi, Commercial Officer with the U.S. Commercial Service at the Department of Commerce. I'm currently based in San Jose, California, but I had the pleasure of spending 5 years in India. This webinar is being brought to you in cooperation by the U.S. Foreign Commercial Service and the ANISA, the Africa, Near East, and South Asia team. The objective of today's webinar is to hear about tips to export to India from experts and be able to ask them questions. In a moment, I'll turn over the presentation to Mr. Robert Saikali, followed by Ms. Satya Narayan and Mr. Deep Singh Gupta. All speakers will be available at the end of the presentation to answer your questions and will provide their contact information afterwards so you can follow up with them directly. For those of you who just joined, you can still log on to the webinar by entering the URL website and passcode per the instructions that were sent to you by email. Just a few quick housekeeping tips to make sure everyone gets the most benefit from the webinar. You'll be able to hear the presentation through your phone and view it simultaneously through your computer. If you're not hooked up through both, please take a moment to do this. If you're experiencing any technical difficulties, please press *0 anytime during the presentation. And again, we will be having a Q&A session at the end of all the presentations. Our first speaker is Mr. Robert Saikali, who is a Vice President and Manager at City National Bank's International Sales and Advisory Group. He has spent more than 33 years in international banking, dealing with foreign exchange, loans, treasury, and trade finance. Over to you, Robert.
Okay, thank you very much. Thank you, Eileen, for the introduction. Again, my name is Robert Saikali. I am the Vice President and Manager of International Sales for City National Bank. Basically, I help exporters and importers to all countries, helping them with their finances, with letters of credit and different type of transactions. Today, I have 10 tips for you, and as you can see, I put in the presentation tips to succeed with the mechanics of exporting to India. The first tip that I have is to develop your plan for exporting your goods or services to India. This is very critical because anytime you are exporting, you have to have a plan that is thought through deeply and documented and researched. So, for example, every plan should define the goals and objectives. For you as an exporter, you need to decide what are you going to sell, how much sales you are expecting. Are you planning to gain market share or simply just increase your sales to generate income and profits? You need to develop the customer profile in India. And India is a huge country. They have in excess of 1.1 billion people. It's more than the entire continent of Europe. It's more than the United States. It has a lot of different languages. It has a lot of different weather patterns and climates. So you need to define who is your client in India. Is it a small company? Is it a medium-sized company? Is it a corporation? Is it directly you are selling to individuals? So you need to document that in your plan. Describe the product and what differentiates it from the competitions. Very important, because if you are selling a product that is already in existence in India, why would somebody in India buy your product versus what is already in the market? So let's say you are planning to sell T-shirts in India. Well, they do have T-shirts in India. But if you have a license, for example, from Disney to print certain characters on the T-shirt, then that differentiates your product from the products that are already in existence in India. You have to decide what type of distribution channels. Are you going to sell directly to the market? Are you going to have a distributor in India? And this is very important because in India, there are different ways to distribute products. For example, there are some companies that use more than 7,000 distributors in India, while others may use 2 major distributors. Depending on the product that you have and the needs, where are you going to sell it in India, then you can determine what is the distribution channel. Developing a marketing strategy. Are you going to hire an ad company to have commercials in India? Are you going to have a contract with the distributor to market your product there? All of that involve costs that you have to budget for and include in your plan. Calculate your cost. That's the biggest thing that you have to think of and calculate as part of your plan. This is the cost of goods sold, which includes all the materials, all the manufacturing costs, all the marketing costs, all the shipping costs, and so on. Once you have that, then you have to think about what price I'm going to charge for my product. That is important because if a similar product is already in India, and it costs much less than yours, then you are going to have tough time in selling the product. Now, that will take us back to what differentiates your product from the competition. So if you have something that is really valuable and there isn't a lot of competition in the market, obviously you can have a better pricing or a better margin. The second tip or pointer is that the U.S. Commercial Service is an excellent source for you. Present that plan after you have documented it and thought through it to the U.S. Commercial Service here in the United States and have them assess your plan because they have presence in India. They have experts on India. They have experience in India, just like Eileen spent 5 years in India, so she knows a lot. But in addition to that, there are commercial attaches in India that have been working there for quite a long time. They studied the market, they did their research, and they will be able to help you modify your plan or add to it or change it because of their knowledge in India. And at the same time, they can help you to decide on the distribution channels. They will tell you, going with one distributor that has a small warehouse somewhere is not ideal for the type of product that you have. While if you have a very precious type of product that does not require a lot of warehousing and distribution, then it may work with a one-shop type of distributor. In addition to that, they have a lot of research on Indian companies, on special markets, and on special products. So if you go to the U.S. Commercial Service website and you put India and you go in and spend some time there, you will find a wealth of research and information that will help you. In addition, they have something called the Gold Key Service. The Gold Key Service is very important, and especially if you are a first-time exporter, let's say to India, it does not cost much, but the help that you will get is tremendous. And the reason that you can get that help without paying tons of money to consultants and so on is because the U.S. Commercial Service is part of the U.S. government. And the National Export Initiative mandates that the U.S. Commercial Service help exporters export more. That's why you get a lot of bang for your buck, because actually it is priced so cheaply that it is, you will spend more on a dinner in somewhere than to do the service by the U.S. Commercial Service. So my next tip is understand and comply with all rules and regulations. Why is this very important? Because, frankly speaking, if you do not do your homework and do your due diligence, you can get in trouble very quickly. And I'm not trying to scare you here. I just need you to understand that there are rules and regulations that you need to know, understand, and follow. For example, the OFAC regulations and sanctions. OFAC stands for the Office of Foreign Asset Control. They regulate sanctions with countries. Now, I know India is not one of the sanctioned countries, but there could be an individual in India or an organization in India or somebody in India that may be listed on the specialty designated national list. It's a list of people that are on the bad list, let me put it this way, with the U.S. government. They could be drug traffickers, they could be terrorist organizations, they could be people that for some reason or another the U.S. government decided that these people should, we shouldn't be dealing with. In addition to there are certain regulations called EAR, or Export Administration Regulations. These regulations specify what products that require a license. So there may be, if you are dealing, let's say, in or manufacturing equipment that goes to the armed forces in India, or that could be used to make bombs, or whatever it is, they may tell you these are prohibited goods or goods that you need to get a license first before you export them. In addition to that, there are boycott regulations. These regulations are designed to prevent certain countries from imposing sanctions on other countries that are friendly to the United States. And basically, this one is related to the Arab-Israeli conflict, where some Arab countries may have in their negotiations with people specify that you cannot deal with Israeli companies or whatever, or the flag of the vessel that is shipping the merchandise should not pass by an Israeli port or whatever. Knowledge of those regulations is very, very important. And we at City National Bank, when we process a transaction, we double check it. We have certain computers, programs that will go in and tell us if something is under the OFAC regulations or under the SDN list, or that it could be something that is prohibited. Investigate and understand India's risk and culture. Very important. In understanding the legal situation in India is very important, because you will be dealing with an Indian company, let's say, to distribute your work, to distribute your product. And there are labor laws, there are certain things that you may need even to consult with an attorney that knows India very well, especially if you decided to have a branch or an affiliate company in India. There are all kinds of different agreements, all kinds of legal things that you need to decide on. Cultural standards, very, very important. As I mentioned, India is a big country. It's more like a continent versus a country. And there are different norms and rules. For example, there are certain parts of India where the weather is very cool, while in other areas the weather is not cool. It's very dry. So there could be certain elements that may affect what is the product that you are selling, or whether that product will sell in this part or that part. There are 23 official languages in India, and there are classes in India. So some cars, for example, people wouldn't drive because normally they use those cars as a taxi. So if you want to sell a car that is used as a taxi, nobody is going to buy it except for taxi drivers. Know your buyer. That also is very relevant to knowing the rules and regulations. You need to know who you are dealing with in India. You have to check that they have sound reputation, established track record, that they are not involved in fraud. And this is something that the U.S. Commercial Service can help you with, because they can tell you if a company or a distributor is in good standing or not. In addition to that, you need to know if that person is going to be able to pay for the product you are selling them. You need to know if let's say you are contracting with a company to sell your product there, are they going to be able to perform the functions that you are expecting from them? So knowing your buyer, whoever that buyer is very important. Find out if you qualify for EXIM financing. Now, obviously, as an exporter, you will need financing. Whether it is you go to City National Bank and ask for a line of credit or any other bank to finance you producing the product that you are selling to India. In many cases, you can be successful because you have a good track record, your financial position is very good, you have positive cash flow, and so on. However, there are certain programs that are offered by the U.S. government, such as the EXIM Financing or the EXIM programs, that helps you getting working capital loans to facilitate exports of goods and services. The loans are made by a bank, like City National Bank is an authorized lender of EXIM. So we can book an EXIM loan up to $7.5 million without obtaining a special approval from EXIM. So you get the loan from us, but it is guaranteed by EXIM Bank. How does it work? The benefits is that it will help you fulfill your export sales orders. You can use your existing inventory and accounts receivable into cash, because those will be considered in the calculations of how much loan you can get. Who is eligible to get the EXIM financing? A company must be located in the U.S., must have at least a 1-year operating history, and must have a positive net worth. What can you export? Whatever you export, as long as it is being shipped from the U.S. and has at least 50% U.S. content. These are the requirements. Now, the description of the product, and you can see it here on the left-hand side of the screen of the slide, you can use that financing to purchase finished products, pay for raw materials, equipment, supplies, labor, and overhead to produce the goods. If you have a standby letter of credit, as a bid bond or a performance bond or some kind of payment guarantee, you can use that money to do that and finance foreign receivables. There is no minimum or maximum for this kind of transaction, for this kind of loan. Now, EXIM normally guarantees 90% of that loan. So the bank assumes 10% of that risk. Repayment terms normally go for 1 year, but it could be up to 3 years, and it could be a revolving type of transaction. The collateral, obviously, the working capital loans are secured by export-related accounts receivable and inventory, including work in process. This is very important. Normally, banks do not include work in process. The borrowing capacity with this, the generous advance rates, and I will show you on the next slide, I think, the advance rate. Inventory up to 75% For foreign accounts receivable, up to 90%. This is really much larger than what a U.S. bank normally would take into consideration or would use to calculate the collateral on the loan. Number 7 is the SBA financing, Small Business Administration financing. It's lines up to $500,000. The SBA Export Express program, the credit decision is with the lender, and it's supposed to be very quick turnaround to approve it or not. The benefits, the benefits to the lender is that they will get 90% guarantee of the amount of the loan up to $350,000, or 75% on amounts over $350,000 up to $500,000. The lender, we use our own forms and procedures to keep the SBA documents to a minimum. We benefit because it is related to the Community Reinvestment Act, so it helps us comply with that. And it will allow us to give loans to small business exporters. The SBA financing gives you speedy approvals, increases your access to capital, flexible line of credit financing. You can finance standby letters of credit, as I mentioned, finance export development activities, participation in foreign trade shows, or the translation of product literature, and so on. There are a lot of benefits, and you are eligible if you are a business for 1 year, not necessarily in exporting, but it could be that you have been in business and now you decided to export, and you have to show that the loan proceeds will support your company's export development activities. Now, what is the most important thing in doing business is for you to secure payments. I listed the most secure to the least secure. First of all, cash in advance. If you are selling to India and the buyer is willing to pay you in advance before you ship, obviously that's the most secure way for you to sell to India. However, if that is not something that the buyer is willing to do, your best bet would be on letters of credit. So the letters of credit, at least you can secure payment if you ship and if the documentation conform strictly to the terms and conditions of the letters of credit. So in that sense, if you are using a letter of credit, when you present the documents, let's say to City National Bank will check the documents for you to make sure there are no errors or discrepancies, and will let you or help you correct them if it is within the accepted time period. Then we will send them to the bank in India that issued the letter of credit in your favor and request payment. The letters of credit are the second most secure ways to obtain payment when you are shipping to India or anywhere else for that matter. The third way is through documentary collections. And documentary collections are basically a way when you ship, you send the documents to India and ask for the Indian bank to collect from the buyer before releasing the merchandise. And the last secure option would be open account, which means that you are sending your product and getting paid later. Investigate the issuance bank risk. That is when you are dealing with a letter of credit. An Indian bank will issue the letter of credit. You want to make sure that the bank is stable, that they can pay when you present the documents, and that they have a good reputation. Again, the U.S. Commercial Service can help you with that. So does City National Bank. We can at least give you an indication whether we like that bank or not. When dealing with India, you may be requested, let's say, to sell in Indian rupees. You have to mitigate your foreign exchange risk because the currencies in the world fluctuate on a daily basis. Obviously, you have to deal with a bank that will mitigate the risk of the Indian rupee for you and go into contracts to fix the rate so that you wouldn't lose money when the rates fluctuate. The same with loans. When you borrow a loan, there is an interest rate that is related, or that's the cost for you borrowing money. If the rate is a floating rate, it could go up or it could go down. So you may want to consider mitigating the risk of interest rates going up and down by doing certain instruments like swaps, where you swap the fluctuating rate with a fixed rate. Again, you have to work with a bank. City National Bank has a full-fledged foreign exchange trading room, and we do all kinds of interest rate swaps. My name is Robert Saikali. Again, I have my contact information on the screen. Please feel free to call me if you need additional information. And thank you very much. Eileen?
Great. Thank you so much, Robert. We will now move to Satya Narayan. Ms. Satya Narayan is an attorney at the Royse Law firm. Her practice focuses on intellectual property licensing and commercial transactions, including cross-border transactions. Satya is licensed to practice in California and India. So Satya, please take it on.
Thanks, Eileen. Good afternoon, everyone, and thank you, Eileen, and to the Department of Commerce for this webinar. So I assist companies with putting in place agreements, best practices, and policies when they want to establish an export presence in India, and to help them mitigate risks with respect to their Indian operations, putting companies in touch with local counsel, chartered accountants, making sure that they have support on the ground in India, in addition to supporting them from here in terms of their obligations under U.S. laws. So my first legal tip is to identify the right export model for your business. And your export model is going to depend on a few things. Number one, who is your customer? Is it a business-to-business transactions that you generally deal with? Are your customers going to be government entities? Is your customer going to be the consumer? And then thinking through and helping clients think through the different risk exposures with respect to local presence, distribution channels, advising them on what permissions might be necessary, and also what restrictions the government of India has in place. And so what is exactly the scope of having operations there. So first of all, you can have a local presence through a liaison or representative office. Liaison representative offices are only for promotional activities, not commercial activity. They're not taxable, but if the office earns revenue in India, they can be taxed very heavily. To establish a liaison office, you do need a letter of no objection from the Reserve Bank of India. Branch offices have a little broader scope. They can do business, but they cannot do direct manufacturing or processing activities. They are taxable in India, and you can repatriate funds from the branch office to the parent. Then you have the wholly owned subsidiary. You can establish your own subsidiary in India, a private limited company or a public limited company. However, the activities of the wholly owned subsidiary are fully subject to Indian law. The contracts that the subsidiary enters into with other Indian vendors or entities are also subject to Indian law. The other thing to keep in mind is if there is any transfer of technology that is involved between the parent and the wholly owned subsidiary, Indian transfer pricing regulations will apply as well. The other export models that you may want to consider are a channel or distribution network. I typically do like that model because it helps companies, U.S. companies, to truly penetrate the Indian market by engaging with regional distributors and also putting in place contracts with the distributors which are governed by U.S. law, and buffering to a certain extent the liability that a company may, that the parent may face, that a U.S. company may face from customers, subject to certain exceptions. You can also enter into a joint venture with an Indian partner to create a joint venture company under the Indian Companies Act 1956. The typical, and I think the biggest issue with doing a joint venture company is, what would be the exit or termination rights if the joint venture's relationship falls out. Joint venture agreements do not bind the joint venture company, so in those instances, you will have to actually include key provisions of your joint venture agreement into the Articles of Association for the joint venture company. Another model is franchising. This is very popular, and I think it's, the Indian franchising industry is growing at 30 to 40%. It's the second largest in the world, and it's very popular for industries such as the food and restaurant industry, education services, travel. There's no specific legislation for franchising, but, as there is in the U.S., but that's not necessarily a good thing because you have to then look to a lot of Indian laws, which then have a bearing on the relationship. The agreement also is really critical in a franchising arrangement. It needs to be very clear about, quality and franchisee performance standards. There are also the Reserve Bank of India has a royalty structure that needs to be observed with respect to franchising. And then just a little bit about retailing as well, which is just on September 20th, 2012, the government of India formally notified foreign direct investment reforms for single brand and multi-brand retailing in India. So in single brand retailing, foreign direct investment of 100% ownership has been allowed, but 30% of the goods must be sourced from India. In multi-brand retailing, it's subject to the approval of the state still, as far as foreign direct investment is concerned. But if the state's permitted, then 51% ownership is permitted. All retail outlets must be set up in cities with more than 1 million population. And there are certain other requirements as well. And this retailing also applies, the foreign direct investment restrictions also apply to e-commerce retailing when it comes to India. So that's just to give you a high level and a general understanding of what you might need to consider when you are putting together your export strategy. One of the key things as part of the first slide actually with the export strategy is to identify what industry-specific regulations apply to you. And this means that you should be working with counsel to identify regulations and permissions that apply to your goods, services, and the export model you've chosen. Foreign direct investment policies in India set industry-wide sectoral caps, and these are typically 26%, 39%, 74%, and several sectors where you have 100% entry is allowed. There is the automatic route and the government route when it comes to obtaining permission. The automatic route is really a route where you don't need RBI or Reserve Bank of India or Government of India permission to for a certain level of foreign direct investment in particular sectors. Government route is when you do need to get permission before you can even invest in those sectors. There are certain prohibited sectors: atomic energy, gambling and betting. Agriculture is a prohibited sector, but it has several exceptions. So one has to look into those exceptions, and we might very well have permission to enter into that field. Then the other specific regulations when it comes to foreign direct investment and repatriation of funds, you have to look at the Foreign Exchange Management Act in India, and also the Reserve Bank's various circulars and policies. And I've provided some resources at the end. I think it's slide 11 or 12, but we'll come to that. But these are all the initial considerations you will have to take into mind when you talk with your counsel, and this would typically be with local counsel that this discussion needs to be had. So my third legal tip is, use contracts. You'd be surprised how many companies I have talked to that were really excited about exporting, and they relied on purchase orders. And or on just letters of intent and memorandums of understanding, which typically set only the business terms. They don't set legal terms, which can, and even on business terms, they can be quite thin. But really, the critical piece here is to understand that, that sets the commercial expectations to have a contract in place. And the good news is, Indian courts respect contracts unless a particular provision is against Indian law or public policy. But as a general rule of thumb, they do respect contracts. So it is best when dealing with your Indian partners to write it all down in a contract. Also, absent a written contract, you have the UN Convention on International Sales of Goods, which may apply. And, navigating that can be problematic. And also, Indian law may directly have an application in terms of how to interpret the parties' relationships. So then my next slide is about drafting effective contracts. And this is really, really important. And I think this is where it's critical to work with both U.S. counsel and Indian counsel to make sure that, the contract is not ineffective under Indian law. The contract addresses critical pieces under U.S. law, including, for example, the export administration regulations and what kind of practices we want our partners to put in place, and to address Foreign Corrupt Practices Act and provisions around that, for example. We would also want provisions to address gaps under Indian law. As an example, you have, in India, you don't have a trade secret law. So you definitely want to address confidentiality provisions in the contract. And then you want to make sure that the contract is tailored to your export strategy. So at a minimum, your contract should include commercial terms, a number of legal terms, going towards protecting and addressing your intellectual property and confidential information, risk allocation terms, and then force majeure, what happens if there is a terrorist attack or if the power goes out, a number of things on that front. And then also termination. I think that is an important piece which parties are reluctant to discuss initially, and it's left to the lawyers to, finesse. But I think it is an important one to review carefully and understand what you may need to do if you need to get out of the contract. Dispute resolution and governing law, these are also important pieces. I'll be talking about them in the next couple of slides. So, if possible, wherever possible, this is what I advise my U.S. clients, require U.S. federal and your state law, California law or New York law or Delaware law for the contract. Indian courts respect a party's choice of law. Where you cannot choose, where the Indian party is reluctant to go with U.S. law, I have defaulted to English law. That is still better for us because of the common law basis. A couple of caveats, though. Even if you choose U.S. law for your contract, there are going to be certain Indian laws which might still apply. For example, export laws, anti-corruption laws, IP laws, which are all based on the local Indian system. If you choose, if you have to end up using Indian law, for example, in the contract, there are still going to be certain U.S. laws that will apply. And these are, for example, export laws, U.S. export laws, and the Foreign Corrupt Practices Act. Certain contracts will always be subject to Indian law. So while the general rule of thumb is where possible, have your contracts with Indian partners be governed by U.S. law, you are going to have situations where if you're contracting with the Indian government or public sector units there, they will insist on using Indian law as the choice of law for the contract. If there are contracts with Indian consumers or individuals, so for example, with an Indian consultant or if you have an Indian employee with the wholly owned subsidiary, those would all be governed by Indian law. notwithstanding your choice of law for the contract. Also note that your Indian subsidiary, when it enters into contracts with other Indian entities, will have to have the contract governed by Indian law. That's the requirement under Indian law, that contracts between Indian parties should be governed by Indian law. Then I think the next legal tip is protect your intellectual property. Register your key export-related intellectual property assets in India. So, for example, with respect to your goods and services, your trademark, definitely register that. Copyrights and patents, the Indian Patent and Trademark Office, they provide very robust regimes and are relatively user-friendly in terms of filing applications. I think the registration process still takes time when compared to the U.S. Patent and Trademark Office, but all the facilities are available to get your intellectual property assets protected in India. So definitely use them. There are a number of boutique intellectual property law firms in India which do a very good job of it, and so it's certainly something that should be on our list. Then when it comes to your Indian partners, including a joint venture company that you set up, make sure to include in the contract no contest terms, meaning that your partner should not be challenging your ownership of your intellectual property. That should be an immediate cause for termination. We have seen, the odd situation where it has actually become an issue when when the contract did not contain no contest terms. Confidentiality obligations, certainly include them and make sure they're robust, keeping in mind that there's no trade secret legislation in India. Indian courts respect confidentiality obligations in contracts, and there is certainly a lot of judicial precedent around confidentiality obligations, but you still want to make sure your contract addresses that. Make sure your contract has sufficient provisions that allow for a present assignment of derivative or new intellectual property. If you as the U.S. company want to own the intellectual property that's created in India, either by your subsidiary or by your partners, because it is derived from your intellectual property, or it's going to be a restraint on your operations. If that third party is going to own that IP, make sure to include a present assignment.
Satya, excuse me, I just want to ensure we have time for all for the final presentation and Q&A as well.
Yeah, absolutely. So I'm going to wrap up in probably 3 minutes. So the last couple of slides, really quickly, require arbitration for dispute resolution in your contract. U.S. judgments are not automatically enforceable in India, and arbitration awards, because India is a member to the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards, will execute arbitration awards in India. Then just a couple of last slides. I think it's really important to be aware of the web of Indian labor law. And I think I'll just focus on one item on this slide. It's quite self-explanatory, but one key thing is, unlike in the U.S., post-termination restrictive covenants on employees, including senior management, are void unless it is in connection with a sale of a business with goodwill and consideration. And even then, non-compete clauses have to be very restricted in terms of time and geography. Finally, it's really important to make sure you comply with the Foreign Corrupt Practices Act. India is 95th out of 182 countries on the Corruption Perceptions Index. So you want to certainly include anti-corrupt best practices in your companies so that you don't have the long arm of the U.S. government reaching out for the missteps of your Indian subsidiaries or even your third-party partners in India. And last but not least, the Indian legal space is changing constantly. We've had a number of new laws put into place in the past few years. And in the works is a Companies Bill 2011, which has been introduced, and it's potentially going to replace the Companies Act. So always keep an eye open for, the changing legislation. My last slide provides some resources. Certainly go and look through them, and hopefully you will have more specific answers there for some of your questions. Thank you.
Thank you. Thank you so much, Satya. That is very helpful. And again, all the speakers will be available at the end of the next presentation. So next we have Mr. Deep Sengupta, who manages FedEx's International Trade Consulting Group and is based in San Francisco. Before coming to the United States in 2000 for law school at the University of Washington, Deep was a customs lawyer in India with KPMG, where he assisted numerous companies resolve disputes with Indian customs authorities. So we have no better person to talk to us about customs and logistics to export to India. So thank you, Deep.
Thank you, Eileen. I appreciate the kind introduction. Good afternoon, everyone. As Eileen said, my name is Deep Sengupta, and I'm going to be talking about the top 10 logistics and customs tips for exporting to India. Now, I've got to tell you the truth. Exporting to India from a logistics perspective and customs is difficult, to say the least. And I give a lot of seminars around the country, and I usually ask my audience, which are the most difficult countries to do business with, in terms of supply chain, logistics, customs. And usually the top three are Brazil, India, and Mexico. So the good news is that hopefully these tips should make you forewarned and help you do your research ahead of time to make logistics and customs a breeze. So the agenda today, I'm just going to take about 10 minutes so that we have time for questions and answers at the end, is three main areas that I see my customers at FedEx lose money is by virtue of landed cost, customs duties, unanticipated customs duties. India has a very complex customs duty structure. It's not just one customs duty. You've got a basic customs duty, a countervailing duty, additional duty, a special additional duty, a surcharge, all of which is added kind of one on top of the other. So what I'm going to be hopefully helping you with is how to minimize your customs duty burden. Another way that we see customers kind of lose money is in terms of delays, because as all of you know, time is money in international business. And we'll talk about certain, tips to avoid clearance delays. And finally, another area where customers run into problems is penalties for, undervaluation or incorrectly marked goods and violations of Indian customs law. And hopefully the tips I give you today can help you prevent avoidable Indian customs penalties. So that's my focus, those three areas to help you save money. So let's jump into clearance or logistics delays first. So based on literally the numerous customers that FedEx has that do business in India, I've come across the top 5 areas or the top 5 pain points where our customers' shipments get delayed at Indian customs. And here's how to avoid it. Number one, this should be a no-brainer, but provide information that's complete and legible. And I know a lot of you might be chuckling, but we see this a lot where, we just can't tell what the product is, what the harmonized code is. Number 2, complete all your necessary documentation in advance and keep your answers consistent across the different paperwork. For example, if your commercial invoice says a different value or a description from your packing list or your airway bill, all of these are red flags that the Indian customs officers are looking for. Point number 3, print the correct country of origin or manufacturer, which says where your product is manufactured. Also remember that India, just like the United States, has labeling rules, which now require a maximum retail sales price to be labeled on your package. So please be aware of the labeling rules. Finally, many times what I see is that the U.S. company will ship their product, but they don't provide a local consignee's phone or fax number or email address. And it's very difficult for Indian customs to, correspond with an entity in the U.S. So just to avoid any delays and your products getting stuck in Indian customs, always try to provide a local contact phone number. And many of you know that, you might have known that once your products get stuck in Indian customs, usually it's very difficult to get it out or ask them to just ship it back to you. So ensuring your products don't get held up right at the start is a good approach to take. Now, there's one area, and that's point number 5 on this slide, which is very important. Anybody who's an importer or the importer of record in India needs to be registered with the Directorate General of Foreign Trade and obtain an importer-exporter code or a business identification number. And without these numbers, you cannot import your goods. And I cannot tell you how many customers I've had at FedEx whose goods have been, held up at customs because they don't have this number, or essentially it's a permit to import. So please ensure you have this. A couple of items I just want to mention as far as clearance goes is that Indian customs operates on a CIF basis, which is cost, insurance, and freight. So always ensure that your commercial invoices, in addition to the value of the goods, also mentions the insurance price and the freight cost. If not, Indian customs will apply a default 1.125% for the insurance and a default of 20% for the freight, which is very high. There's another point that I need to mention is that when you do business around the world, many of you might be conversant with paperless invoices or, just a standard format invoice. But Indian customs requires that the commercial invoice be signed on your letterhead. So that's another thing to note. So with that said, those are the main clearance delays. But let's get into the customs rules, which is on the next slide. Now, Indian customs rules, just like as Satya and Robert mentioned, thanks to the British legacy, the rules are very complex and there are many of them. The first thing that I would recommend you do before you import to India is determine if your products need an import license. There are essentially 4 major types of commodities in India. One is free, which means it can be imported without any license. One is restricted, which needs a license. The other is canalized, which means that only certain government departments or agencies can import that good. And the other is prohibited. Now, it's very important, obviously, to ensure that your products don't need a license beforehand, because obviously if you import it and then you realize you don't have a license, that will delay the process. The second item I want to mention is harmonized code classification. This is one area that Indian customs is very keen about. A harmonized code is a 10-digit number. In India, it's 8 digits. In the U.S., it's 10 digits. And that determines your customs duty rate. Now, around the world, the first 6 digits are the same, but the last 4 or the last 2 digits in India's case is always country-specific. Now, it's very important that you list all your commodities in the commercial invoice and the correct harmonized code, so that Indian Customs doesn't stop or question your shipment. Number 8 is valuation, and I must tell you, of all these 10 tips, our customers, we see U.S. companies get tripped up on valuation more than anything else, because the Indian Customs Agency is extremely vigilant that no import is being done that makes them lose their share of government revenues through customs duties. So if you're a U.S. entity and you're sending your product to your Indian entity, they're going to question if the value is correct and arm's length, especially if it's a warranty-type replacement. They're going to question and want documentation that it's really, a warranty repair with no consideration paid. So valuation is really an area where if there's any suspicion that there's some fraud or undervaluation, Indian Customs Special Valuation Branch could, investigate and then want your product catalog and, ask you for a whole host of information. So always remember that have your valuation fair, and there are many acceptable methods of valuation, the primary one being the transactional value method. There's another point I want to make is about hand carry, and that's under number 8. Now, India has its baggage rules, and baggage rules pertain to passengers who bring in commodities. Many times, customers who either ship stuff that could be carried in a suitcase don't insist that their engineers declare it, and that's a wrong practice. And I always recommend, if you have anything that's high value or dutiable in your baggage, always declare it to Indian Customs, just to avoid any bad press or any potential penalties. And just remember that there is an exemption in place of about 25,000 rupees, but anything beyond that needs to be declared. The last 2 points, number 9, if you're shipping products that are going to go to India for a trade show or an exhibition and going to come right back, try to use what's known as a ATA carnet. And you could just Google it, and you'll see the 2 agencies that issue carnets in the States, and that saves you a lot of headache. It's like a passport for your goods. And the other point I want to mention is many times companies ship samples, and they just say no value samples, but it's very important to provide, your letterhead which says this is a sample, and also mark your contents as samples in order to get that treatment. So with that said, I just want to say, although Indian Customs is difficult to deal with, once you're forewarned and you're well educated with these major tips, it should be a breeze. Let me just tell you why I believe, knowing the Indian rules ahead of time is going to help you, because we've seen through all our customers that doing exports to India in the correct fashion really results in fewer exams, fewer penalties, fewer information requests, fewer delays, and that all leads to your greater competitive advantage. So in the interest of time, I'll end right here, Eileen, but I'm delighted to answer any questions, or if anyone needs any further information, please feel free to contact me. My email address is right here on the slide. Thank you.
Great. Thank you so much, Steve. We will now move to the Q&A part of our webinar. So if you'd like to ask a voice question, please press *1, and an operator will connect you. We also have a box, the Q&A box up at the top, so we invite you to type in your questions on the screen as well, and we will take questions both by phone and by typing them in. Operator, do we have any questions?
At this time, there are no questions. Again, to ask a question, please press star 1.
While we're waiting for the first question, I wanted to mention an opportunity that would be could be of interest for the participants. We are recruiting for a trade mission, a multi-sector trade mission to South India and Sri Lanka the first week of February 2013. And trade missions are really the best way to not only meet with potential partners, but come away with market insights and really get to know the country and understand how to do business. Each participant will benefit from one-on-one matchmaking meetings in each city. These are pre-screened, lined up well in advance. You vet the companies, and they also vet you, so you're able to have a very substantive discussion right away. And each city also, you will have benefit from networking events, briefings from government officials and successful companies, and site visits. So if you have any questions about this trade mission or other trade missions that the U.S. Department of Commerce is conducting, please just let me know.
We did have one question. Naj Chirakomba, your line is open.
Hello.
Yes, please go ahead.
Hi. My name is Naj Chirakomba. I'm from FirstMed USA. I started exporting used medical equipment to India. I have exported few equipments, started for the last 3-4 months. I would like to know whether you can throw any kind of information in this area.
Sure.
Absolutely. This is Deep. I'm happy to take a question. Now, for the longest time, and this isn't just India. I mean, if you look at many developing countries, there's always been rules against the import of second-hand goods, and the policy has always been to, spur domestic manufacture. And you see these rules prohibiting used capital goods, not just in India, but also in Brazil and some other Asian countries and South American countries. Now, used medical goods, there shouldn't be a problem. There used to be restrictions on used goods, period, but over the last 15 years, it's been relaxed. So used medical goods should not be a problem. What's very important is to get the valuation right. Now, India is a signatory to the WTO customs valuation code. So what this means is you need to arrive at a correct transactional value using the acceptable methods of valuation, arrive at a good price which is not questioned by Indian authorities. Also ensure that your commodity is properly described in your commercial invoice, and try to find a harmonized code. And if you need any help, feel free to reach out to me. I'm delighted to provide you the harmonized code. So those should be the major considerations.
Oh, thank you so much.
Just to add to that, when I was stationed in India, I helped a company sell refurbished medical equipment to second-tier cities in South India, and they came on a trade mission, and after the trade mission, within a month, they sold $700,000 worth of equipment, and since then, it's been a couple $1 million in these second-tier cities. So there's a great demand for refurbished medical equipment.
Oh, that's very good to know. I mean, we have just started this business. And, I'm trying to look at the opportunities and data. I'll be coming on this trade mission. I'll enroll for that. Thank you.
Okay, wonderful.
Good luck to you.
So we have another question. Probably this is a written question, probably best answered by Sandeep. Please discuss customs clearance of goods used as warranty replacements and or used post-sale.
Sure. Now, I understood the first part, which is discuss warranty replacement, but the second part I didn't quite understand. It said use for sale?
Post-sale. I guess after sale.
Okay. I'm still, now warranty replacement, as you know, is, suppose a U.S. company, let's take a medical equipment, sells a medical equipment to somebody in India, but the product is for, it gets defective, and then the U.S. party provides a replacement under the 1-year warranty. It provides a replacement at no cost. So more I'd say sophisticated customs regimes who've had this problem time and time again, like in the U.S. and the EU, they've actually built into their tariff structure provisions such as Chapter 98, which allows for American goods returned. India has recently introduced rules for warranty replacement, and the rule is that, number one, it needs to be mentioned on the paperwork that it's a warranty replacement, and you also need to include, kind of a certificate of indicating your warranty program. And there's a couple of other requirements which is on the FedEx website as well. So, Eileen, if you have this person's email address, I can send you this information regarding the steps to go through to ensure the correct warranty replacement import.
Sure. So, Todd, feel free to email Sandeep to email Deep. If not, I will send him your email address.
Absolutely. And Eileen, I'll send you this information right away so you can forward it on to Todd. Now, the second part of the question, it says after sales. After sales is really a plain, simple commercial transaction, so it's not very difficult. It's not very different. In that case, your value, you actually have a commercial value, unlike a warranty, which is zero, right? $0. So in an after-sales situation, you'll be putting in your full sales price, your harmonized code, complete description, and you'll have to pay full customs duty. But, yeah.
Great. Thank you.
My pleasure.
Operator, do we have any other questions by phone?
Yes, your next question comes from Joseph Drennan. Your line is open.
Hi, my question's for Deep. And I was calling, we manufacture medical devices, and I was going to send some samples to a diabetic foot surgeon in India who had requested that I send these with no value on the invoice and list them for medical research. He's going to do a trial with them. I was unclear from what you had said in your presentation. Is it okay to list them as no value as long as the actual value is below $200, or do we list them with no commercial value but list the price as long as it's less than $200? I wanted to try and get a little more clear on how that would work to best avoid those getting held up in customs and our good doctor getting a phone call.
Right. Now, the reason Indian customs and customs agencies around the world are skeptical with samples is because the samples provision is always misused, I'm sorry, I'm not suggesting it's misused here, but I'm just explaining why the government applies greater scrutiny. So what the regulations, what the requirements are now is that you should mention it on your commercial invoice, and I can send you, if you have my, or Eileen's email address, I can send her the requirements for samples right away. And what it requires is that not only does it explain on your letterhead that it's a sample for medical research, but also the goods need to be marked as a sample. And the U.S. has the same laws, which says that if it's really a sample, the goods need to be mutilated or marked as a sample to prevent resale of that commodity, right? So does that answer your question? And also remember who is the importer. If the doctor is the importer, then he should have that registration code that I mentioned, the BIN number or the IEC number. Or if you're using a door-to-door courier, then you could be the importer as long as it's an informal entry below a certain value, which it would be in this case.
Okay, yeah, we were going to use a door-to-door courier, and thank you for including that. Yeah, I'll follow up with you by email. Thank you very much for the information and the presentation. I appreciate it.
My pleasure. Good luck.
Any additional questions, operator?
There are no other phone questions at this time.
Well, great. Well, thank you, everyone. I would like to invite you to, if you have any questions in the next couple of days, feel free to shoot me an email, call me, or get in touch with one of the speakers. We will be doing a third webinar as part of the South Asia webinar series in the beginning of next year. The date and topic is to be decided, so if you have anything on your mind or issues that you think would be of interest, please let me know because we do have some flexibility in structuring that one. Also, if you did not receive the link to the Doing Business in South India and Sri Lanka webinar that was recorded on October 11th, please let me or Rachel know because we want to make sure everybody has that. So thank you again for joining us. Thank you so much to the speakers, Satya, Deep, and Robert. This is a truly great information you all shared, and we look forward to helping you do business in export to India. Thank you.
Thank you. Bye.
Thank you.
Thank you.